Thank you. Thanks to John and Jeffrey for getting us set up with sound, and Rick for helping us get set up with the video. And welcome to one and all to this, our fourth and penultimate session of our Living with Dying conversation series here at the Cathedral. And let's begin with a word of prayer. Teach us, Lord, to be encouraged, to stand fast, and to boldly say with confidence, "The Lord is our helper, the Lord is our strength. Though we walk through the valley of the shadow of death, we will fear no evil. The Lord is our supplier of all things. The Lord will supply all that we need." Lord, help us to dismiss our fears, to put our trust in you, and to listen to your calm, comforting, and still voice. In your precious name we pray. Amen. So I'm delighted to welcome you all here to this fourth session after three really wonderful evenings together, and a special word of welcome to the folks who might be tuning in on the live stream or after the fact, which will be in the future. We'll be having these available for folks to review. I'm really pleased and delighted to welcome Talia Prophet here with us this evening. Talia is a partner in the Moncton office of Cox & Palmer and joined Cox & Palmer back in 2013. She's a fully bilingual practicing lawyer and litigates in both French and English. And she has appeared at all levels of the New Brunswick courts, as well as the Supreme Court level in Nova Scotia and Prince Edward Island. Talia's practice is focused on civil litigation, particularly medical malpractice defense, class actions, personal injury, and property damage. She's written a number of articles for national insurance magazines. She's presented to legal and medical communities on litigation and risk mitigation, and she's involved heavily and widely in her community on various boards and committees. Talia lives in Shediac River with her husband and twin daughters, and happens also to be related by marriage to our very own Katie Young Morris. So appreciations to Katie for letting us know about Talia and helping extend the invitation to Talia to speak to us tonight around, in particular, the legal considerations surrounding medical assistance in dying. So without further ado, welcome, Talia.
Okay, so thank you very much for having me today. I appreciate that introduction as well. So my area of practice, and the reason why I have a particular interest and knowledge in the area of medical assistance in dying, is because of my work doing medical malpractice. So it has certainly come up in the hospitals. There's a lot of considerations to take into effect. It's very new, even though, as you'll see, there's been some cases around for the last 25, 30 years in Canada. But we're only recently seeing that it's now legal, and they're deciding whether or not to make certain changes and updates to that as well. So I am starting with a little disclaimer. The only reason being is that I understand this might be aired later, and you probably expect that from a lawyer already. But things change all the time, so it's accurate as of today, as far as I can tell. But also, it shouldn't be construed as legal or medical advice. Speak with your own lawyers or medical professionals if you have specific questions about your particular case, or your mother, or your sister, your child, or whatever. Okay, so first of all, why MAID? Originally, and even when I was much younger, we used to use the term assisted suicide. So the reason why that's really not in favor anymore is because advocates for assisted suicide, or for this area, strongly oppose the use of that term, basically because when referring to physician-assisted suicide, they prefer the phrase medical assistance in dying. And this is to help distinguish it from suicide and other areas where the person is not terminally ill and is not eligible for medical assistance with their death. So the legal framework in Canada, the first legal framework was really implemented in the Criminal Code in 2016. So you might think that there's actually a law out there that says medical assistance in dying legislation. There is not. What it meant was they actually have a section of the Criminal Code now that is called medical assistance in dying, and they added that in because before this, it's illegal to kill someone or to be a part of their death or to assist in their death. It's not illegal to commit suicide, though, however. And really the first case that brought about that, that change in the legislation was the case of Carter versus Canada. In that case, despite it leading to the modification of the law in 2016, it really stood on the shoulders of the first case dealing with the question of whether medical assistance in dying was legal. And that was the case of Sue Rodriguez. So it happened back in 1992, 93, and I would have been just a young teenager at the time, and I even heard about this in the news. So you might remember her story. She was suffering from ALS and facing a rapid decline into paralysis, and she wanted the legal right to have a qualified physician's help in ending her life at a time of her own choosing. However, assisted suicide was illegal in Canada, and actually at that time was illegal everywhere in the world except Switzerland. They had a clinic called Dignitas, which comes up a bit later as well. And actually, if you, at that time, had helped someone in perpetuating their own death, it was punishable by up to 14 years in prison. So certainly it was a very heavy burden and not something that someone would just do anyway to help a friend or a family member. So she applied to the Supreme Court of British Columbia in December of 1992 to have Section 241B of the Criminal Code, which is the section that prohibits assisted suicide. She wanted it to be declared unconstitutional, and there were several sections of the charter that she was relying upon. So she lost her trial. Then she appealed to the British Columbia Court of Appeal. She lost that one as well. Then she applied to the Supreme Court of Canada. And the Supreme Court of Canada doesn't take every case, but this was certainly the first of its kind, and no case had come before on that issue. So they accepted this case, and they wanted to look at the law and have all the arguments and really pronounce from the Supreme Court, which is our highest court in Canada, what the position was at the time in Canada on that issue. So there was a majority 5-4 of the judges ruled that that section of the law was constitutionally valid and it did not violate the charter. So although it was recognized that her right to security of the person, which is Section 7 of the charter, was denied by that section of the Criminal Code because it deprived her of personal autonomy in her own decisions about her body, the majority nevertheless believed that the prohibition against assisted suicide upheld principles of fundamental justice and therefore did not violate that section of the charter. So their decision was based on the idea of the sanctity of life and the state's interest in protecting human life. They argued that assisted suicide was widely considered to be morally and legally wrong, and that lifting the prohibition could potentially lead to abuse, certainly amongst vulnerable people. So when I say the majority of the court, so there was 9 judges on the Court of Appeal at the time, only 5 decided that way, and then 4, so it was very, very close. There was a minority. So the minority judges argued the opposite, or contrary to what the majority said. They said the prohibition of assisted suicide was arbitrary. In effect, a physically able person can commit suicide, which is not a criminal act, while a physically disabled person commits a crime when she asks for help. So that is a big dichotomy really there, and certainly at least almost half of the Supreme Court recognized that back in 1993. So this is a picture of Sue Rodriguez, and one of her quotes is that, if I cannot give consent to my own death, whose body is this? Who owns my life? So despite her not winning her court challenge and going all the way to Supreme Court, she did ask for assistance from a physician who anonymously helped her with her death in February of 1994. So now that brings us to the actual case that changed the law. So here, this case was also brought by someone who was diagnosed with ALS, Gloria Taylor, and she was joined by Lee Carter and Hollis Johnson, who assisted Miss Carter's mother, Kay Carter, and they had taken her to Switzerland to use the service of Dignitas, which was an assisted suicide clinic, which had been in place long before even the original case of Rodriguez. They were also joined by Dr. Shoichet, a physician from BC who was willing to participate in physician-assisted dying if it were no longer prohibited. So all of them together came and they were arguing the same section of the Criminal Code once again. So section 241B of the Criminal Code, where it says everyone who aids or abets a person in committing suicide commits an indictable offense. And again, it would be 14 years in prison. And here the question was section 7 and 15 of the Charter. Those were the areas that they said it infringed, which was the rights to life, liberty, and security of the person, and the right to equality. So here was the equality of a disabled person. So I have some quotes of the individuals involved. Gloria Taylor is the one up top. She said, "It doesn't make any sense that it's legal for me to commit suicide, but it's illegal for someone to help me die at peace, without pain, in the comfort of my home, with family and friends surrounding me." And then the second case is that of Kay Carter, where her daughter said, "My mother, Kay, was a lifelong supporter of the Dying with Dignity movement. She lived her life with passion, independence, and resolve, and her independence extended to insisting that she would have choice and control over how she would leave this world. My mother was a great lady, and I feel like I am honoring her memory by participating in this legal challenge." And it is quite a challenge when you go to the Supreme Court. Like, it is many years, lots of work, and certainly I can imagine the kind of preparation that would have been involved. So the Supreme Court in the Carter case, now this is 20 years after Rodriguez, and really there hadn't been any significant case quite of the status of Rodriguez since then. So they decided to revisit that case and concluded that it was appropriate for several reasons. So appropriate to revisit something that had already been decided. The reasons were that there was significant evidence available from other jurisdictions where assisted suicide is permitted. So since Rodriguez, there was other countries where, and Quebec as well, that had its own little law with regards to this particular area of question. And there was now more evidence regarding the effectiveness of safeguards to protect vulnerable individuals, which was not available to the court 20 years earlier. Also, legal principles have evolved. So in Canada, it's common law, and we base it on our whole system, our whole legal system is based on evolution, and it reflects the community and the people that are in your country at that time and their values. So it is meant to evolve with time, and so certainly they said that legal principles had certainly evolved since 1993, dealing especially with the proper approach to interpreting Section 7 and new principles that had emerged regarding the proper approach to interpreting reasonable limits under Section 1. That's a lot of legalese there, but super interesting to me. A number of legal issues also arose in Carter that were not conclusively decided in Rodriguez. So often you'll find like there's a big Supreme Court case, the cases are sometimes 150 pages long. There's a lot of different things that are dealt with at the time. So there were some peripheral issues that came up in Rodriguez where they didn't really decide them, and they thought, here's now our chance to have that decided. So the Supreme Court was unanimous and actually concluded in favor of Carter, and concluded that the law, which was an absolute prohibition on assisted suicide, was an infringement of both Section 7 and, that should be 15 of the Charter in the case of Ms. Taylor, and infringement of Section 7 in the case of Ms. Carter and Mr. Hollis. And the infringement was not justified by Section 1 of the Charter. The court gave Parliament 1 year to allow it to respond and enact new laws. In the meantime, Ms. Taylor was granted a constitutional exemption that allowed her the option of physician-assisted death under several stipulated conditions without risk of exposing someone to criminal charges. So incidentally, and this is the Supreme Court as it was at the time, so a unanimous Supreme Court decision means they're very convinced, there's no question this is the way it should be. But incidentally, the Chief Justice at the time of this decision was actually Chief Justice McLaughlin, and she was one of the minority judges back in Rodriguez. So I have a feeling she probably was quite instrumental as well in getting them together and changing the law, essentially. This is a case where sometimes, in order to change the law in Canada, either the legislatures can go change the law, or the Supreme Court can say, your law's not right, you better go change it, and that's what they did here. So what was in fact changed? So the MAID provisions in the criminal code were enacted in 2016. So before we were talking about section 241, they added section 241.1 to 241.4. So they added a bunch of sections regarding medical assistance in dying. And they apply to medical and nurse practitioners who, at the request of a person, they can administer a substance to that person that causes their death, or prescribe or provide a substance to them so that they may self-administer it, and in doing so cause their own death. So there's kind of two ways that that can be done. Someone who might be suffering from something like ALS will not likely be able to administer their own medication at the end of life, and they would require that first level for someone else to administer it for them. This removes any legal negativity and consequences for someone in the position of a nurse or a medical practitioner who would help them with their administering their own death. The second would be if someone would be able to administer that on their own because of the nature of their issue, when it is time or when they chose to do that, they would be able to do that, and that they would feel comfortable doing so, then they're also allowed to do it, and that would be legal. So there are a number of eligibility criteria that are put in place. There's 5, and it seems simple enough, but each one of them have a lot of different kind of considerations to take into effect. The first is that you are eligible for Canadian Health Services. Sounds like it goes without saying, but just like someone visiting Switzerland might want to use those services. I'm not sure about the laws in Switzerland, but here, someone visiting from another country would not be permitted to use the Canadian healthcare system for medical assistance in dying. I'm not sure about all the immigration laws and things like that, whether, like, at what point, if you're a permanent resident, if you have a visa. I'm not familiar with all those situations, but if they are a permanent resident who has Canadian Health Services, then they would be entitled to be able to do that. Second one is that you are at least 18 years of age and have capacity to make health decisions. The third, which is really a very big criteria here for eligibility, is you must have a grievous or irreparable medical condition. Fourth, you make a voluntary request for MAID. And 5, provide informed consent. So I'll go through each one kind of in more detail. I kind of already explained the first one here about eligibility for Canadian Health Services. A person is eligible if they are covered by provincial health care or would be so covered upon completing any applicable waiting period. In general, MAID is not available for visitors, like I said. Capacity. This is one I deal with all the time in my own practice. So in order to receive MAID, a person must be at least 18 years of age and must have capacity to make decisions with respect to their health. So unlike testamentary capacity, so I could assess someone's ability to make a will or a power of attorney if they came to my office. We have a series of questions that we would ask as well, just to make sure that they are of sound mind at the moment when they're signing a document, so they know the legal consequences of what they're signing. Just like that, the person must have medical capacity to receive, for receiving MAID, and they're assessed by a medical or nurse practitioner. So that's not something that anyone else can assess. What I often see in my practice is family members saying, this person does not have medical capacity, when the doctor says they do. And there's a lot of considerations here because not everyone's going to agree, right? You know, you might have a family member who wants to do that, and you maybe have some family members that oppose that. And one of the main areas that they oppose it with is saying, they don't have the capacity to make this decision. I don't want them to do this. And that's why medical practitioners have a lot to think about and a lot to put in place in their own documentation to make sure they've properly assessed capacity. In case they're ever questioned later, they have that documentation to rely upon. So the next criteria is grievous and irremediable medical condition. So it's only satisfied if each of the following, so not just one, you need to have all 3 of these exist. A person's medical condition must be serious and incurable. It must be physical, although it need not necessarily be fatal or terminal at that moment. The person's capability must be in an advanced state of irreversible decline, although natural death need not necessarily be reasonably foreseeable. So you have to be in a position where, certainly a medical professional believes that you're in irreversible decline, there's no chance of getting better. Even though that decision can be made, it doesn't mean that you can only make that decision when you're 2 weeks away from death. That decision can be made before your death is reasonably foreseeable. And lastly, a person's condition or state of decline must cause them enduring intolerable suffering, and their condition cannot be relieved under conditions they deem acceptable. So there may be ways in which they could deal with the suffering and all of that, being heavily medicated and things like that, but that might be a situation where it's not relieved under conditions they deem acceptable. And of course, those things would be decided with a medical practitioner or a nurse practitioner. So the big question that has come up in recent days, I would say, weeks, months, and in the last few years is, does a mental illness meet this criteria? Currently, it does not. So presently, a mental illness, it's still in the criminal code, and it's quoted from the criminal code. A mental illness is not considered to be an illness, disease, or disability for the purposes of determining MAID eligibility. So as a result, a person who suffers solely from a mental illness, and unless they have a physical disability or physical illness that would also render them, available for MAID, they are excluded from receiving that treatment. So as of the time of the 2021 amendments to the criminal code, the exclusion of eligibility was scheduled to be repealed. So they were going to get rid of the exclusion. So there's a lot of double negatives. They love to do this in laws. But they were going to basically make it possible after March 17th, 2023, for people with mental illnesses to receive MAID. One of the first of its kind in the world. This is not the direction that a lot of countries are going, but it's something that certainly the legislatures in Canada decided that they should put in there, but there's a twist. So this was based on a Quebec decision which found the criteria of reasonable foreseeability of natural death eligibility criteria to be unconstitutional. So they had a question in Quebec about mental illness. Quebec has they don't follow common law, they follow civil law. So we always take Quebec decisions with a grain of salt when it comes to treatment for the rest of Canada. But the twist is that before that date, they changed it, and then they changed it again. So on February 29th, 2024, legislation to extend the temporary exclusion of eligibility for MAID for persons suffering solely from a mental illness was changed again until March 17th, 2027. So it received royal assent, meaning if nothing else changes in March 17th, 2027, it will be allowed for mental illness. But I think there was a number of advocacy groups, a number of questions that had not yet been determined, and they were worried about putting it into place without having all that done. This, like I said, would allow time for provinces and territories to prepare their healthcare systems for the change, and would allow practitioners to participate in training and become familiar with available supports, guidelines, and standards. Okay, so now the fourth criteria, voluntary request. So a request for MAID must be voluntary, it must not be made as a result of external pressure. Now, I know that sounds like no one would ever do that, but sometimes you might see family members who might encourage that, or there might be reasons why there's external pressure for some reason for someone to go ahead with something like that. But the medical practitioners that are assessing individuals really do a great job, as far as my experience anyway, of really making sure they're on their own, making sure that they have very frank discussions with them, making sure that this decision is a voluntary decision that they are making on their own, and it's one that they want to make. A friend, a family member, or a power of attorney cannot make this decision for the individual. You would be surprised how many people come into a hospital with a power of attorney and say, I have a power of attorney, I get to make all decisions for this person. And then the doctor says, it doesn't count yet. This person still has capacity. A power of attorney does not come into play for medical reasons unless the person has lost their capacity to make their own medical decisions. So your own medical autonomy over your own body is preserved as long as you have capacity and you get to make your own decisions. And medical and nurse practitioners are very aware of that and very conscious that they are getting the decision of the patient, not the decision of family members, friends, or someone holding a legal power of attorney. A healthcare practitioner will generally ask questions of the individual making the request to ensure there's no external pressure, like I said. And then the last criteria is informed consent. So this requirement means that the person must have received all information needed to make their decision, including with respect to the medical diagnosis and available treatment options, including the option to receive palliative care. They'll go through all of that with them to make sure, like, this is definitely the decision you want to make. Also, they may make that decision and then something happens or time goes by and they decide, I don't want to do this anymore. And they can withdraw that at any time while they have capacity. So the next criteria, I have a star in there, is tricky. The informed consent must be provided when they request it. That's a for sure, no question about it. But then again, immediately before they receive it. So you can imagine a scenario where if you're dealing with a terminal illness, you had capacity, made this decision. As you're dealing with a terminal illness, though, your capacity might wane or might fall off altogether, especially if it's a neurological disorder. All of a sudden you can't make that decision anymore. Are you still allowed to get made? So they have more sections on that in the criminal code than they're trying to deal with that. I expect there will be legal challenges to certain sections. So for that second consent that you have to make before you actually go through with it, if the person's natural death is foreseeable at the time of their initial request for MAID, the requirement for consent immediately before receiving MAID may be waived under specific circumstances set out in subsections 241.2 to 3.2 to 3.5. So they are very specific. I brought them with me. They're long because they want to make sure that they're not doing something that someone wouldn't want them to do, right? So they try to make sure there's things that need to be signed in advance when they know that this particular illness will render them incapable at some point. All that to say, if this is a decision that someone that you know wants to make, there's things they need to keep thinking about. They can't just say, I decided way back then, it's good, we're good to go, because you need to make sure that if, and in a lot of cases, people's capacity can change, that and with your medical practitioner, they will also guide you through this, if that's what you choose to do, through that other sections to make sure all the things are in place so that if that's what you wish to do, it can go ahead, or if someone you know is wishing to do that. They are specific, and a medical practitioner will walk you through those, or through your family member if that's what they choose to do. Okay, so ultimate decision-making autonomy, super important in medical everything. Courts have recognized MAID as a constitutionally protected right. So there was a case, it's called Sorensen versus Swinemeyer in Nova Scotia Court of Appeal. And this is one where a family member challenged someone's ability to do this. In fact, it was someone's wife. So here, the court held that once a person is determined to be eligible to receive MAID, they have a constitutional entitlement to it. So a really big switch from back in the Rodriguez days. Now it is your constitutional right to get MAID if that's your decision. So preventing or delaying an eligible person from receiving MAID is actually a violation now of your Section 7 Charter rights. So things have certainly evolved since Rodriguez. So in Sorensen, the court also held that the wife of a man seeking MAID did not have a private interest standing to challenge her husband's MAID eligibility on the basis of her status as spouse. That goes for friend, child, power of attorney, if they have capacity. Personal autonomy in medical decision-making is to be respected and protected, permitting her standing to question the outcome of the MAID assessment because of her status as his spouse would fail to acknowledge this fundamental right of her husband's. So that's pretty much the legal framework in Canada when it comes to MAID. There's other considerations that I just thought I'd add in here. Mental health is something that certainly now is looking like it'll be included in the future. Questions and advocates that have spoken about this issue are concerned, I think, about adding mental health because the concern being, have these people been given the opportunity for treatment, and because it's difficult to seek treatment sometimes, and there's waiting lists and things like that. So you'd hate to think that someone simply didn't get the treatment they could have had to help them in a mental health issue. and instead went for this option. So that's some of the concerns that advocates are expressing about the mental health inclusion. Also, this is very new in Canada, as one of the first of its kind to include this. Also, the difficult role of the medical nurse practitioner. So that's when I'm contacted often, and like I said, it's often about capacity. It's often about the power of attorney and things like that, when people think they just don't agree with their family member's decision to go ahead with this. And it can be very difficult because it is that person's decision to make, and it can be very difficult for families to accept that that's what they want to do, and to get behind them and to be there for them. And it's really on the medical and nurse practitioners to help them through that, when previously their job was do no harm and save and help and cure, and now it's help them at their death. But I think the medical practitioners that choose, and it is a choice. I am advised that if you're like, I morally don't feel like I can do this, I don't want to be a person that's going to be involved in that. If you're a nurse or a medical practitioner that does not feel okay with that, you're not forced to do that. But I think a lot of medical and nurse practitioners that are helping with this is because they recognize their clients or their patients want this dignity at the end of their life, and they don't want the suffering. So I think discussions with family members regarding their wishes in advance is super important. I think that would alleviate a lot of issues at the very end, when it's a very stressful time already. And when, if it's done right, it can be a good experience, and that someone is dying with dignity and fulfilling their personal wishes. But it's certainly important because there's all these questions at the end, you know, if they had capacity and legal obligations and things like that. So having those discussions early with family members and friends is probably the best option to avoid as much of that as possible. And then finally, personal medical autonomy. I can't say that enough. It really should be your own decision, even with children. Sorry, this does not apply to children because you have to be 18 years of age and things like that. But medical autonomy with children, they even try to respect that at an earlier age than you might expect, because it is their own bodies, and making decisions about their own bodies should be your own. So whether it's your child, an elderly parent, if they meet the criteria, the decision is theirs. And when I said it's your child, your adult child. So just keep that in mind about medical autonomy. So that's really what I had to present today. There's lots of time for questions if you have them.